approach, sir?
Yes.
Thank you, sir.
Okay.
I'm David Toulis. It's an honor to be here, sir. The law in dispute is named after James Lee Atwood, age 30, who was killed in a car accident. He was killed in southeast Memphis by another driver 7 hours after that driver had been cited by police for failing to have proof of financial responsibility. His name is Roderick Maggot, age 24, from Cordova. He was criminally prosecuted for reckless homicide. The Atwood law, named after him, has a legitimate purpose, and that is to monitor those who are required to have proof of financial responsibility and to close an enforcement gap. A lawful constitutional legislation. Is the petitioner in this case liable for performance under it? He's had no accident, no suspension. He's not in the Department of Safety's enforcement system. Atwood monitors suspendees who trigger the operation of the law against them by letting their special insurance policy lapse. The petitioner has not done any act to bring himself under the law. The Department of Revenue, DOR, applies the law in error. Now, I have sympathy for the department. The Financial Responsibility Law of 1977, or it's called the TFRL, is not a tax act. It's not in the tax law book. In 2015, the General Assembly handed this department the job of extending the financial responsibility verification and enforcement system. The General Assembly knew that it did not have familiarity with this law, and it required cooperation between revenue and safety. The department ignored its mandate. The TFRL is run by the Department of Safety under Section 203 and 204. DOR always is the order-taking functionary. It is the probation officer effectively. DOR always suspends tags by notice from the Commissioner of Safety, according to the statute. Safety investigates, safety determines, safety requests, safety decides, and then it gives notice to revenue to suspend someone's registration tag. But the department, under color of Atwood, has created its own program. It calls this program independent from and parallel to the main body of law, the TFRL. It cuts out the Department of Safety and Homeland Security. It creates effectively an independent tax authority, getting 2.5% skim on auto insurance premiums under TCA 56-4205. It creates a list of non-customers, an unauthorized list, and targets these non-customers for suspension. Many millions of dollars of extra taxes come in through the universal mandatory auto insurance program that the department operates. It's corporate capture, but I suggest that that language is a euphemism. It's an inch-wide law. TFRL is an inch-wide law, but it's administered by the department as if it were 5 yards wide. There's no clear directive making the petitioner, in this case, liable for performance using the enforcement provisions in Section 139 or the protocol provisions in Section 210 to create a duty. Those provisions are cited as creating an obligation upon me to become an insurance industry customer. It's effectively being given a speeding ticket without there being a posted limit. The Department of Safety says all is good with the petitioner. All is okay. He's got a good driving record. But the Department of Revenue is punishing the petitioner forcing him to a futile and impossible act, and that is buy owners or operators insurance. I really can't buy high risk special insurance that's in the statute as the third option. Only a motor vehicle liability policy, however, is proof of financial responsibility. The penalty, the petitioner, backing up, the petitioner is being penalized for not doing an act that's not required by law. The department is violating Section 214 of the Atwood law that says nothing in this part, that is Part 2, shall alter the existing financial responsibility requirements of this chapter, close quote. But the department is requiring POFR, or proof of financial responsibility, of all registrants at all times, without release, forever. Sections 114, 116, 117, and others make it clear that the obligation to have POFR it comes to an end at the end of a suspension. In the earlier law, it said 5 years, up to 5 years. These laws of release contradict the respondent's policy. There are three phrases, I think, that suggest the nature of this case. Very short phrases with just a few words each. The first is in 55-12-202. They are three words, quote, have been met, unquote. The EIVP, the Electronic Insurance Verification Program that runs the EIVS, which is the system, we call it EVIS for short. The EIVP verifies the POFR requirements of Chapter 12, quote, have been met with a motor vehicle liability policy. That's one of three types of insurance that the statute describes: owners, operators, and the MVLP for short. And the phrase have been met is past tense. That presupposes a financial responsibility obligation already exists. The suspendee, the one who has conditional use of the privilege, the suspendee has that policy, the MVLP, the motor vehicle liability policy defined in Section 102, to meet an obligation. The obligation is a deal with the Commissioner of Safety. He's high risk, he's dangerous, he's been determined either by a court or the Department of Safety to be irresponsible. And yet, the state allows him to use the public road. He's allowed to use the road. He has necessaries, he has rights to exercise, he has to make a living. Automobility is essential to life in the United States and the state of Tennessee. He is irresponsible, but he gets to use the road on the condition of having that particular policy. The petitioner is not in such a situation. The second phrase is, if you want to look at your printout of the case of the provisions I'm citing, is Section 210, the letter G. There's a reference to automobile liability insurer of record. 210 is the provision that describes the department's notice steps to the scofflaw, the person who's supposed to have insurance but doesn't, and he's been found out. What makes an insurer of record? What does that mean? Sections 120 and 123 explain what is involved in being an insurer of record. 120 is about certificates and certification, and it reads, quote, proof of financial responsibility may be furnished by filing with the Commissioner of Safety the written certificate of any insurance carrier duly authorized to do business in this state, certifying, unquote, and the key word there is certifying, quote, that there is, in effect, a motor vehicle liability policy for the benefit of the person required to furnish proof of financial responsibility. This certificate, it goes on to say, quote, shall give the effective date of the motor vehicle liability policy, which date shall be the same as the effective date of the certificate, and shall designate by explicit description or by appropriate reference all motor vehicles covered thereby. what that points out is that these special policies apply to the individual in any car he uses. Insurance doesn't attach to individual cars as it occurs under the department's policy. These policies attach to the individual, whatever vehicle he's using, and to get the policy, he has to identify which cars he drives in. Section 123 has the back end of this policy and program of certification. It's about cancellation or termination of policies. That's 55-12-123. And it says when an insurance carrier has certified a motor vehicle liability policy under 120, insurance so certified shall not be canceled or terminated until at least 10 days after notice of cancellation or termination of the insurance so certified shall be filed with the commissioner, that's of safety, except that such a policy subsequently procured and certified shall, on the effective date of its certification, terminate the insurance previously certified with respect to any motor vehicles designated in both certificates. The third phrase that I think is worth looking at as you review these briefings is in section 139C1, and that's the phrase pursuant to this section. 139 makes it an offense if a party fails to provide POFR, if he's required to, quote, pursuant to this section. Now, the department in its brief on page 2 misrepresents the law in paraphrasing it. It's the paragraph that begins, quote, in 2002, the General Assembly amended the TFRL to add so and so and so. The two sentences of interest begin this way, quote, that procedure authorized officers to request evidence of financial responsibility from drivers involved in an accident or a motor vehicle violation at the time of the accident or violation, with the failure to provide proof constituting a misdemeanor offense, close quote. This is the statute that's used in every criminal prosecution for no insurance, as they say. It goes on to say, quote, by making it an offense to fail to provide proof of financial responsibility to an officer upon request, close quote. And I emphasize that phrase, to an officer upon request, because that's where the error is. Quoting again, registrants now had to comply with the financial responsibility requirements beforehand to be able to provide the requisite proof. The phrase pursuant to this section confines the offense to an encounter-triggered event. That would be an accident where the police arrive or a traffic law enforcement traffic stop. The petitioner has not been in such an event to fall under this provision. Pursuant to this section, as a phrase, modifies the type of insurance in view, which is the MVLP, not its being provided to the officer. There's a roadside scene in the statute at TCA 5510-108, where the officer dealing with people involved in an accident requests information about insurance. There are two types of insureds. There are regular insureds, and then there are the special high-risk insureds who have the certificated policy that complies with the insurance industry standards. Those standards are described in the record in some detail. The group is called IIMCVA. The first sentence, two sentences again. The first sentence is about the regular traveler not under obligation. Reports, it says, quote, reports prepared by a law enforcement officer shall include information pertaining to the insurance policy, including the name of the insurance company, if known, of each person involved in the accident. The second sentence describes how the high-risk user on suspension on conditional use is treated. Quote, if a person has a certificate of compliance with the Tennessee Financial Responsibility Law of 1977, compiled in Chapter 12 of this title, issued by the Commissioner of Safety, a copy of the certificate shall be included in the report. So we have a clear indication that the person who's high risk, who has the privilege, has this special policy with the certificate. It's called the SR-22, but he also has on the policy papers itself reference to the statute, wherein the papers themselves can be proof of or evidence of his financial security in the use of that car that day. Certification is a dispositive issue in this complaint. So is the hearing authority in the department. The Department of Revenue is the tax department created under 4/3/1903, and it administers Title 67 of the tax code. It doesn't have general police powers. It doesn't have a road safety interest or outlook. Its officers in their peacekeeping police power role and inspection role have authority limited to Title 67. The authority for the hearing, any hearing under this law, is in the Department of Safety. That is in Section 103 that makes a couple of important points. And it says, quote, except as otherwise specifically provided, unquote. There is no specific provision for that department to have the hearing that's went on for 2 years. Continuing, quote, except as otherwise specifically provided, the commissioner shall administer and enforce this chapter. He's the boss. It goes on to say, quote, may make rules and regulations necessary for its administration and shall provide for hearings upon request of persons aggrieved by orders or acts of the commissioner. There's also another reference in 104 making reference to his authority to have hearings under the financial responsibility law. Safety's authority is express. The department's role in using Atwood, again, is request and notice triggered. It does not have a parallel and independent authority. Its role is subservient, the statute says. Its role is ministerial because Jeff Long, the current commissioner, has authority over the entire chapter. It has no authority for a hearing. The hearing officer, Brad Buchanan, in his 62-page order against me, had no subject matter jurisdiction to even address the question. The authority is expressly given elsewhere, resulting in a denial of the petitioner's due process rights. An added insult is the deprivation of his interest, his property interest, before the hearing. That's unconstitutional as developed in the briefs. And I can just mention one case, Bell v. Burson. The hearings below are null and void. The department has no authority to write law. This program accomplishes through interpretation what the General Assembly has not ordained to happen. As an administrative agency, the Department of Revenue has very limited powers. Those powers are noted in TCA 45103 in the construction of the Uniform Administrative Procedures Act. And it says, among other things, that administrative agencies shall have no inherent powers and shall only exercise the powers conferred on them by statute or by federal or state constitutions, close quote. The independency of this program is evidenced in the transcript of the deposition by Jennifer Landfair, and that would be this document here. If you want to refer to it later, you can. And on page 6, we see this independency that the deponent did not read Part 1 of the law. When's the last time you have read the Atwood statute? She says, recently this week. What about the TFRL? Her answer, Part 1, I have not read Part 1. The department does not recognize exemptions and exceptions in the Tennessee Financial Responsibility Law. Pages 11 and 12 in the transcript make that clear that I highlighted, pressed on this point. She kept saying, the exceptions that the department recognizes are those within the Atwood law, unquote. And then she says, quote, the department recognizes the exceptions that are in the Atwood law. And finally, I pressed her and she said this, quote, those do not apply to the Atwood law. The department only recognizes the exceptions within the Atwood law. There was no cooperation, there is no cooperation with safety. Page 13 of the transcript, page 14, point out that the Department of Revenue does not cooperate in surveilling the SR-22 high-risk insureds and who became high risk because they violated the TFRL or they have a court order or a court judgment against them. She says, no, we do not. And I asked her, does the department consult with DOSHS regarding its list of high-risk drivers under effective probation? No, we do not. On page 29, did the department consult with safety in building EVIS? Yeah, the answer is no. On page 48 of the transcript, marked highlighted in yellow, is there a relationship between the financial responsibility department or office in DOR with the Department of Safety's financial responsibility division? Unquote. Answer, no. There's no relationship with the industry. That's on page 37. And on page 42, I asked her about section 130 that says it shall be unlawful for the commissioner of revenue to re-register any motor vehicle tag suspended under this part. That's part 1. And she says, we do not need any permission from safety to reinstate the registration. And you don't get permission, I asked her, and she says, correct. The department cannot, under our law, use enforcement and notice provisions as a substitute for a missing liability statute that makes it clear to members of the public what their duties are. The agency may administer obligations created by the legislature, but it may not create the obligation, is the argument in my complaint. What the legislature does not impose directly cannot be imposed indirectly through administrative procedure. We have in 2024 the recent U.S. Supreme Court case Loper Bright versus Raimondo. That's again Loper Bright Enterprises versus Raimondo at 603 U.S. 369 2024, ending the Chevron deference when laws are ambiguous. We don't have ambiguity here. Now, the first word has been found or shown to be ambiguous, but that reassertion in the Supreme Court of the limits on administrative power or the limits on legislative power goes way back. In 1867, in Cummings versus Missouri, which is 71 U.S. 277, the court says what cannot be done directly cannot be done indirectly, unquote. My petition has requests beginning at paragraph 105 and following. My requests for the court is personal, that there be a tag restored to petitioner's 2000 Honda Odyssey minivan. Secondarily, that the commissioner be ordered by proper judicial authority to decertify what I call the Eye of Sauron, the surveillance tower on top of towering over the landscape and burning out the weak and the poor and our liberties. He has authority and a duty in section 212 to certify the operation for use by law enforcement, and I'm insisting that there are too many irregularities, 28 abrogations of the law that I've cited in my briefings to allow any certainty about this program. I request that the order that comes from the Honorable Court defend the constitutional TFRL. It is constitutional law in the public interest. There's absolutely nothing wrong with it under God's law or men's laws. Defending this program from predatory use. The predator is the Commissioner of Revenue, David Garagano, creating 40,832 criminal convictions per year. That figure derived as an average of 7 years, reporting by Commissioner Garagano and Jeff Long, the Commissioner of Safety, to the General Assembly. That's 112 convictions a day, and since the law is so expansive, and since parties under suspension are relatively few compared to the entire population, it is a true harm to the public and a true harm to the poor. Brad Buchanan and the Deputy Commissioner of Revenue both say in their pleadings in the record that the purpose of the law is to bar the poor from the road. That is an unconstitutional purpose, and that is not how the law works. That's not its moral premise whatsoever. I'm asking also for injunctive relief of my, I would argue, sufficient complaint filed July 21, 2025. I'm not here pretending any kind of class interest, but I do understand that if I'm getting relief, it has to be not as a personal favor or something exceptional. It has to be because the law is properly described and properly recognized, and that the program that's operating now be shut down. The obedience to the law as secured by this court will secure me in the future and all other petitioners, all other registrants in the future. And again, the particulars are in paragraph 105 and following, and I'm requesting a thorough review of all the parts of this broken system. And now that I'm done, Your Honor, I wanted to ask, do you have any questions? What's the hardest question that you can ask me about what I'm claiming here in front of you?
I think what I understand is you're saying the legislature has set up an appropriate system. It's just being administered by the wrong department. Is that one thing you're saying?
No, sir.
Well,
I'm not saying that.
Okay.
The program is given to the Commissioner of Revenue to operate. EVIS is his job. It's under the supervision of safety. His job entails connection with use of safety's records, and he should have consulted with the Department of Safety in creating the program, which he didn't do. So it's not that the wrong department is administering it, it's that and Jeff Long is not in this case at the moment. He's not been joined in this case, so I can't say really anything about him and whatever his duties are or neglect thereof. What I am arguing for is that the Commissioner of Revenue has to comply with the statute and not cause public harm.
Okay. Then how has the Commissioner of the Department of Revenue not complied with the statute?
Because he's rejecting the certification requirements of what constitutes proof or evidence of financial responsibility. The billfold insurance tab you have in your billfold, Your Honor, is not proof of financial responsibility. It just shows that you're a customer of State Farm or Grange or some insurance company. A policy like the one you have on your motor vehicle or your car is certified, and so it's certified under the IICMVA standards, and it has a certificate, and that certificate is the well-known, long-established SR-22 form, and that form and those policies are the sole ones that this tower with burning eyeball on the top is supposed to look out for, using the data supplied by insurance companies regularly, which can show that a person liable for having insurance under duty to have POFR is current. Because if that person stops paying, he's now on the road without security. The law wants the risky driver to have security. TFRL operates backwards in time and forward in time. The backwards looking version deals with the qualifying accident, and you have to show POFR within 20 days to the commissioner. And if you have insurance, you show proof of your insurance by getting the SR-22 attached by your company to your policy and sending that in. The forward-looking parts of the statute are upon suspendees. And those suspendees are the parties who elect to have security by insurance. And if they lapse over the period of the suspension, they're in trouble. And they're going to get notices from the department, hey, you're not current with your policy. You need to keep that up and show evidence that you've renewed your policy, because you cannot use the road without security. You are dangerous, risky, and irresponsible. You have to have insurance for the duration of your suspension.
Okay. And you're saying that part's okay, in your opinion?
Yes, that's the way it's supposed to. That's the way it runs.
The forward-looking part is okay?
Yes, the forward-looking part is correct and just, and the Department of Revenue is there verifying those people under suspension. It has no authority to force anybody to become a customer of insurance or to pay the commissioner $65,000 per car used. There's no authority for that. Its authority is to verify, as it says in 202 on your printout, to verify that people who have to have POFR have that policy current. It verifies something that already exists.
And this is an administrative review, so what do you see my role as?
I see your role as fulfilling the review requirements in the UAPA.
Okay.
There cannot be, the program or policy in dispute cannot be arbitrary and capricious. It has to fit within constitutional limits. It has to comply with the statute, and it has to be, your ruling has to be based on all the material facts that apply, and the material facts about me are not in dispute. I don't have insurance. I use the roads. I'm now not able to use my minivan for purposes in commerce. All I can do is use it for private purposes, but I have a right to have the tag so that I can have the privilege. The privilege is a special thing that I have a right to have, and it injures me to not have it continue as I paid for it.
And of those factors under the administrative review, standard of review, what factors are you saying is applicable to what the agency did here?
I've delineated in writing the constitutional violations. I've also shown 28 abrogations of law, contradictions that in a way are just maddening. How is it that safety says you're okay, but you're suspended over here by revenue? So we have departments at cross purposes. They're not cooperating. We have two moral theories operating. One is that every member of the public is irresponsible and has to be compelled to have security at all times. And the other one says, well, we are concerned, as for insurance and security, only with those who have shown themselves, either by adjudication or by our findings, that they are not responsible. So we have two departments with a clashing analysis of what the law says.
And what would you want me to do to solve that?
Since the harms are great and have been going on since 2002, I'm requesting a monitor or special master, sir, that would save you from having to deal with the particulars of things that are part of the problem. For example, there is a certification that people who are applying for driver's license fill out, and they say that they agree to abide by the Tennessee Financial Responsibility Law. Well, right there, that's language devised by the Department of Safety. That language should specify that I agree to comply with the financial responsibility law in case of an accident or other requirement. So there are things like that which will prevent the harms being done now from recurring. And what about restitution? If we have that many thousands of people convicted under a ultra-virus program, do they deserve notice of compensation or a way of clearing their record? I'm not saying this is a tax case. This is not a tax case where In the case that we've already seen in writing, the court ruled that individual taxpayers who wanted a refund from an illegal tax had to file their own petitions for a refund. There was no way that could be done by the court. Here, with a correct claim about what the law says, the court can direct that the law operate properly, and that those who are falsely convicted, either for no insurance or follow after offenses like driving on suspended, they can have, if they're convicted of driving on suspended because they didn't have insurance and their tag was suspended, those are two things that, one directly caused the other. So those kinds of things, I would think the special master would be equipped, paid by the state to work on your behalf. I figure it would take a couple of years. The more immediate repairs can be done by simply recalibrating EVIS. If even that can be done in a day, where the department then can recertify that EVIS looks at MVLPs among the customer base. They get all that data. They can't look at everybody. They have to look at those people who have to have financial responsibility by their own agreement. They want the license, and so they agree to have this insurance. And if they're going to keep their license, they have to become the customer. Those are the only people who are coerced, effectively, to being customers of the insurance industry. I should not be coerced to be a customer, Your Honor. Thank you for your question, sir.
Yes, sir.